Okay, I'll start here in a moment. Okay, well, I'll go ahead and Beth, with your approval, I'll go ahead and begin. Was it okay now?
Go ahead for me.
Thank you. Okay, this is Tim McKinless calling from Prime Architects and Engineers. Actually, today I am in the office, so that's kind of an interesting thing. Actually, just to show that we are kind of getting somewhat back to whatever called the new normal, I guess, is I was just finished an onboarding orientation with an employee. So things are starting to pick up where we're actually bringing, people back to work, field staff, but people back to work. So that's at least an indication or a bright spot that things are getting back to where they need to be. I'll just leave it at that. So with that brings us to today's discussion, which has to deal with the new norm or the new norm and what it's going to look like. So we're starting to look at what does it look like regarding individuals, working from home, balancing that. How about now in Ohio, following the 5 protocols? And what is that associated with? And what does the office look like? What questions should you be asking? What questions should you not be asking? What does it look like for people coming back into the office? What are some of the key ideas that maybe we've seen as individuals and on a legal front of what are some options that we have? We all see, like when we go to Kroger, we see that sneeze panel. Do we have that at a reception area? Do you not? How do you handle individuals that are mandated to wear masks and either refuse to or do so, and guests and everything else? So I don't want to go too far, but really there's a lot of new information, a lot of new things coming out. And that's really why we're happy to have on the line 3 gentlemen from Western Herd LLP. And really we're looking forward to hearing what is the best. What do the best and brightest minds in America have to share with us? And that's who we have on the line today too. So I'm just going to go ahead and start with Jack Klusnick. Jack is a partner with Western Herd. He's chair of the firm's litigation section and employment and civil rights practice group. He focuses his practice on litigation, employment, labor, civil rights, intellectual property, copyright, trademarks, commercial, and education law. He's got extensive travel experience, both jury and bench, in matters involving wrongful termination, age discrimination, sex discrimination, race discrimination, sexual harassment, directors and officers liability claims, and commercial litigation matters, including restrictive covenants and trade secret claims. Jack did receive his BA summa cum laude and his MA with distinction from Ohio University. Jack received his JD from Yale Law School. He's granted admission to the Ohio Bar in 1977, but he looks much, much too young to have graduated in 77, and subsequently to the United States District Court for the Northern and Southern Districts of Ohio and Sixth Circuit Court of Appeals. He's a member of the Ohio State Bar Association, Labor Section Council, and he's presented at the Midwest Labor and Employment Conference on the topic of professionalism and civility in depositions, mediations, and settlement. He's a member of the Cleveland Metropolitan Bar Association, the Defense Research Institute, Ohio Association of Civil Trial Attorneys, the Manos Inn of Court, Employment American Inns of Court, and the Court of Nisi Prius. Okay, I hope I'm not butchering that too bad. I apologize if I am. He is also a volunteer of the CMBA 3Rs teaching program, a board member of the nonprofit Panelway Partners, whose mission is to extend the towpath trail to downtown Cleveland, a member of the regional facility of the National Institute of Trial Advocacy, and a formal adjunct faculty member of the Case Western Reserve University School of Law. Jack is a participant of the CMBA committee to develop and present a series of interactive seminars on professionalism and civility for lawyers in various aspects of the legal practice, including depositions, mediation, and settlement, and business transaction. He's also been a presenter at the Council of Smaller Enterprises Annual Small Business Conference on the topic of the workplace investigative process and has conducted diversity training for supervisors of a large governmental employer. I'd also like to introduce Warren Rossman. Warren Rossman. He's a longtime partner with Weston Herd, LLP, and now of counsel, earned his BA in political economy at Johns Hopkins University, go Baltimore, and his JD from Case Western Reserve University School of Law. In addition to his Ohio board admission, Warren has admission to practice before the United States Supreme Court, the United States Court of Appeals for the Sixth Circuit, the United States Court of Appeals for the Seventh Circuit, and the U.S. District Court for the Northern and Southern Districts of Ohio. Warren's practice covers a number of areas, including employment and labor law, defense of school districts and other political subdivisions, civil rights litigation, and appellate practice. He's litigated cases in many diverse areas, including employment discrimination, voting rights, medical malpractice, insurance coverage, premises liability, and property security. Warren is an AV-rated attorney by Martindale-Hubbell, and since 2013 has been recognized by Martindale-Hubbell and ALM as a top-rated lawyer for labor and employment. Warren has also been named by Super Lawyers as a top-rated schools and education attorney in Cleveland, Ohio. In addition to being a member of the Ohio State Bar Association, Warren is a member of the Cleveland Metropolitan Bar Association, where he has served as chair of its bar admissions, fee dispute arbitration, and law school liaison committees. For several years, he's been a member of the CMBA's Judicial Selection Committee and participated in the Bar Association's 3 R's program for a decade. Warren is the author of 3 articles that have been published in the Cleveland Metropolitan Bar Journal, titled Discrimination Law 101, that was in May of 2011, Teacher Discipline, May of 2013, and Spring and Insurance Coverage, June of 2005. In 2017, Warren was a presenter at the CMBA's 17th Annual Labor and Employment Law Conference on the topic of defamation in the employment law context. So we're happy to have Warren with us as well today. And finally, it's my pleasure to introduce Jonathan A. Good. He is a Western Herd partner. Jonathan A. Good, he has extensive experience in employment and labor, healthcare, business, transactional matters. Specifically, John represents his clients in Fair Labor Standards Act, retaliation, ERISA, workers' compensation, and related employment claims. He also advises on medical board issues, long-term care matters, and HIPAA compliance. John has tried 20 cases to jury verdicts in state and federal courts. John received his BA from Dartmouth College and his JD from Cleveland Marshall College of Law. In addition to the Ohio Bar, John has admission before the United States District Court for the Northern and Southern Districts of Ohio and the Northern District of Illinois, and the United States Court of Appeals for the 6th and 7th Circuits. Within the community, John has served on the board of directors of New Avenues to Independence, Incorporated, and the Ohio Physicians Health Program. And with that, I'd like to turn the microphone over to Western Herd. Thank you, gentlemen. Very proud and pleased to have you on board.
Thank you, Tim. We appreciate and are grateful for those kind words you had. Thank you, everybody, for joining us today. We are going to present about a 30-40 minute presentation on labor employment issues regarding the restart of the economy and what happens when employers and HR professionals are bringing their employees back into the workplace. We were asked to provide commentary and insights on the ADA, the interactive process, the recent EEOC guidelines, and some OSHA considerations, all the employment stuff that comes with bringing workers back into this workplace when the COVID-19 is going on, when people are afraid of getting sick, when people are sick. What are employers supposed to do? How are we supposed to handle some of these new requirements from the government, from individual employees, so that the employees can come back to work safely, and get their jobs done in a safe and efficient environment? This is a real hornet's nest. We are starting to see a variety of situations starting with employees coming back to work. And I kind of break this down into three categories of people. Employees who are currently sick or symptomatic. That's the first category. The second category of people are individuals who are not sick and they're not disabled, but they are medically fragile due to underlying conditions. And the third group of individuals that we are starting to see as attorneys for employers, where HR professionals are calling up and saying, John, Jack, Warren, how do we handle this situation? The third category of people are people who are not sick and they're not medically fragile due to underlying conditions. They're just really scared to come back into work because they don't think it's safe. So let's talk about these three situations. The first situation is the individual who is sick or symptomatic. As an employer, as an HR manager, what do we do with these people? I call this the easy situation. And we all know by now a lot of the signs and symptoms of COVID-19. Here's an example. Christine has a fever of 104, a dry cough, and has visited someone who has been diagnosed with COVID. And you're calling her back to work. We are reopening. And she says, well, I'm kind of sick. I'm kind of symptomatic. We as HR, by now, it should be automatic reflex. Well, if you're sick or symptomatic, you are to stay home till you are fever-free without the use of fever-reducing medicines for 72 hours. Your symptoms have improved, and 7 days have elapsed since onset per the CDC guidelines. I highly recommend and refer you to this Center for Disease Control. They have a wonderful website that sets out all their guidelines for a variety of situations. And this information can be found on the CDC website. Now it gets a little bit harder. Actually, it gets really hard. An employee who isn't sick, but they call you up and they say, I don't want to come back because if I get the COVID-19, it's going to wipe me out. I am high risk for a bad outcome if I get COVID-19. Are you really going to make me come back to work? And this is an actual situation that it has made me, Jack, Warren, and I think about, and we debate it. It has had me and my HR clients consider this and think about this on a deep level. Here's the example. An employee, George, is not sick, but he's medically fragile. He has diabetes. He is morbidly obese. He has a 40-year smoking history. He has COPD, and he probably has about 10 other conditions. But he can come into the work site. He's not right now sick, and he's not disabled from work. He can come in and do the job. But if he gets COVID-19, he is what the Senate CDC calls high risk. So George submits paperwork from a physician. He submits FMLA paperwork saying, I need FMLA leave. And this is what the physician writes. Patient has medical condition that places him at high risk for poor outcome of COVID-19. Will need to restrict exposure potential. How do we handle this? Well, this leads us into one of the questions that prompted us for this presentation is, what are some helpful hints, some insights that you, Weston Hurt, can provide ACEC employers and HR professionals on how to interact with these difficult situations? So this George presents to us with FMLA paperwork, but this is both an FMLA and an Americans with Disabilities Act situation. You can ask questions or request further medical documentation whether the employee has a disability. So first thing I want to know is George really, is he sick at this moment under the FMLA, under the ADA? I want to know, is George really disabled? And so now you under the ADA, the employer has a duty to interact with George to flesh out exactly what he can and can't do. Here's some sample interactive questions. George, do you have a disability? What is the disability? What limitations do you have from your underlying conditions? How will you, being off work, effectively address these limitations? Will another accommodation effectively address the situation? And so I envision the conversation with George going like, George, what's your disability? Well, actually, John, I'm not disabled. I'm just really scared to come back into work. Okay, you're not disabled. Well, you have COPD, you're high risk. What limitations do you have from this disability? Well, I really can't be around too many people because of the high risk of exposure and infection. Okay, then you as the employer engage, well, this is all the social distancing that we're doing. These are all the administrative controls that we're putting in the workplace. We are staggering shifts so that we are limiting the amount of people in your workspace. So as we go through these questions and do a sample mock-up interaction, hopefully you're getting to see how this interactive process works. When you ask these open-ended questions to George, all of a sudden he's giving you information, and then you're giving information back to him, and you're working the problem. And so George says, well, actually, I don't want to come into work at all. Okay, well, that's your request for an accommodation, George. How about we just have you come into work on staggered shifts or different times, or this is what works for us, and see if your proposed accommodation works for George. At the end of the day, as an employer, you want to ask question 5 on this slide. How will a proposed accommodation enable the employee to perform the essential job duties? You want to cut to the chase and find out, how can we help George, given his situation, do his job? So the CDC recommends that in this new normal, as Tim described it today, I call it the new normal for this week, because everything changes on a weekly basis in these days and times. But from an HR perspective, the CDC recommends flexible leave policies. And from a legal perspective, we as lawyers are recommending to our clients that you develop and revise up your leave policies. We're seeing a lot of creative, flexible leave policies being written, and the employers call us up and they say, can we do this? How does this look? Or, Jack, can you draft me this remote work from home policy? So employers are busy right now rewriting their leave policies. The ADA requires that we interact with George, and this is not only an opportunity for George to tell you what problems he has, but it's an opportunity for you as the employer to explain all the safety precautions that you have taken. And I know you have taken a lot of precautions. So now's the time to cash in on all your hard work. You've disinfected. You practice workplace discipline. You are providing PPE, masks, or requiring it. Signage, you're posting signage all over the place at your workplaces. You're staggering your shifts. You are either conducting temperature checks or you're requiring employees to take them at home before they come in. And so you're compliant with all the federal, state, and local health laws. So this is an opportunity for you to, again, tell George everything that you're doing, and hopefully that will calm him down. But the bottom line is, in George's situation, he will either return to work, you'll have a flexible leave policy where you allow him to telework. But if he won't telework and he won't return to work, in this situation, I'm probably going to recommend that George is eligible for some type of unpaid leave. And this might be a new flexible leave that you have to work in to your leave policies. Why do I call it unpaid? Well, I call it unpaid because he's not eligible for FMLA or the new emergency FMLA because he's not sick. And he is afraid of getting sick sometime in the future. So on that, I don't think he qualifies for any type of paid or unpaid FMLA. And under the disability leave, if you put him on a disability leave and he goes to your third-party UNUM or short-term disability, we are seeing that the short-term disability carriers are denying these claims because the high-risk individuals are not physically disabled. They are just afraid of getting disabled in the future. So UNUM or MetLife, their internal guidelines are saying George is not eligible for short-term disability from us. And he's not going to be able for unemployment because you as the employer have work eligible for him. Now, George might go to unemployment and claim, I am medically unable, and unemployment is so liberal these days, or all days, that he might get it. But for George, I recommend an unpaid leave. One outside the box suggestion, I had one or two employers inquire about, can we offer an advance of future sick time, of future accrued vacation or sick time? And yes, the answer is yes. If that is another creative leave policy that some employers, as they rewrite their leave policies, they're putting in, well, we will offer you, if over the course of the year, you're entitled to 10 days sick leave, but since it's May 11th now, you've only accrued 5, we'll allow you an advance on the other 5 if you need it. But again, I'm going to recommend that if you do some of these flexible, creative leave policies, that you write them down. Now, here's the third situation. And a colleague of mine described this as the scaredy cat situation. And I don't mean that derogatorily. I just thought it was kind of a cute nomiker to describe this situation. This is the individual who is not sick. They're not medically fragile. They're just scared to return to work. And I know you have these situations because this is a very common situation. Tim calls to work. He refuses to come back to work, and he says, I'm not high risk and I'm not asymptomatic, but I'm just afraid to come to work. How do I know it's safe? And I think you're going to start getting these questions a lot. And here's a sample response. Tim, we take safety seriously. Here's all the steps that we've taken. We are compliant with federal, state, and local health guidelines. There are no recognized safety and health hazards in our workplace. We have no reported COVID cases arising from work. So bear with me. I'm going to go back a slide or two. Here, George. And 99% of my employers take safety extremely seriously. So I know you do too. And so again, this is a chance for you to say, we implemented a cleaning regimen, workplace distancing, signage, staggered shifts. This is a time for you to brag about every single thing that you have done and to reassure your employees that you take safety seriously, you take their safety seriously, and that you operate a safe work environment. You are compliant with all federal, state, local health guidelines. There are no recognized safety or health hazards in our workplace. So Tim, we would like you back to work. And I get a lot of calls from stressed employers saying, John, we really need this guy back to work. He's the only one that can do this particular job. What can I do to get Tim to come back to work? Well, if he's not sick, not fragile, just scared, and you're interacting with him, telling him everything that you've done to create a safe workplace, and he still doesn't come back to work, it's my recommendation that you have the right to implement your attendance policy. You can start disciplining him. He's absent from work. That's the leverage you have. And if you have to go down the discipline absent track and terminate him for cause, he's not going to get unemployment. So he might start feeling the leverage once you start implementing that discipline absent from work policy. One of the options you have is to allow people to work from home. And so employers, that you should ensure your employees have the proper tools. The one key suggestion we have is you're going to have a difficult time managing work assignments, communication, attendance. But if you're having non-exempt hourly employees work from home, I think the most important takeaway here is you must have the employees keep accurate time records of the work that they are performing. Have the employees write down the time that they start and the time that they stop work. Have them write down the times that they take a break and when they restart. The wage and hour laws require employers to keep accurate time records. But if your hourly non-exempt employee is at home, how can you track that time? But that you have the duty of mandating that they track their time in case they claim, oh, I worked 80 hours that week and I'm due overtime. You don't want to be in a situation where somebody is claiming they are entitled to overtime and you're not paying them. One way to police that is to have them write down their own time. And the courts really like to see employers have that in writing. When you're going through your handbook, update your handbook saying that if you're teleworking from home, you are required to record your time and turn it into your supervisor. If you have a written policy mandating timekeeping, that will give you an added defense to a wage and hour claim. So create and update your remote work policies. What kind of lawsuits are we starting to see from this new normal? Well, a couple takeaways is that we shut down in mid-March. And within a matter of a couple weeks, we are starting to see lawsuits. So people are not sitting on their duff. They are filing lawsuits if they feel they have been wrongfully terminated for anything related to this Family First Coronavirus Relief Act. Here's two examples. One is in Pennsylvania federal court, and one is from Cuyahoga County Common Pleas. Stephanie Jones worked as a director at Eastern Airlines. In mid-March, she requested 2 hours a day flex time to care for her son who was home from daycare. She asked a couple different times. She followed up with a couple different people, and she was fired on March 27, 2020. Eastern Airlines said, Stephanie, maybe this isn't a good match for you. We are not going to be able to allow you 2 days flex time. So she sued for interference and retaliation for requesting a flexible leave. Two things to take away from this case is that Stephanie is asking for attorney's fees and double damages. She also sued her individual managers and supervisors in their individual capacity. Their names and addresses are listed as parties on the complaint. Stephanie just didn't sue Eastern Airlines. She sued Eastern Airlines, Jonathan Good, Jack Klosnick. No, she didn't sue us, but if we were her supervisors, she would have sued us. So, as HR managers, we need to start taking this very carefully when people have these tough return to work situations. So think through it, call your attorneys if it's a complicated situation, but really take this seriously because you as a manager or supervisor or decision maker may be individually sued. In Nadu, Judson Service out of Cuyahoga County, this was also a lawsuit where she was fired in March and she filed the lawsuit in April. She was an event planner at a nursing home. She asked to work from home remotely. The employer said, no, we want you in the nursing home. She asked to use accrued PTO. The employer said, no. She complained, hey, I'm in the nursing home the way you want me to, but everybody still keeps coming within 6 feet of me. And she was fired. So she also filed a lawsuit. What are the best practices for dealing with these situations? Designate a leave expert in your organization. Have one person that is the master of all this craziness so that you have one consistent person responding, one consistent response when these variety of situations start coming in at you. Train your team on ADA, FMLA, the interactive process, the CDC guidelines, the new stay-at-home orders. So as the HR, train the frontline managers, train your HR team, the generalists, the admins, the managers, the directors, train your executives, the vice presidents, so that the more knowledge, the more depth you have in responding to these. Designate one communications person to deal with the phone calls from the wives, from the husbands, from all the employees. And finally, document your file. I know you've heard this for the past 10 years from all your legal training seminars, but the interactive process, it's great to interact with the people, but then document that you made the phone call, document what was said in the conversation. And when Jack Warren and I go into court for our pre-trials, the judge is going to want to say, okay, this is what plaintiff is accusing you of doing. What did the employer do? And Jack and Warren can say, well, we have 10 documents that's corroborate and show when exactly we interacted with the employee, and this is what they said. So the more evidence and attempts you show of interacting with the employee, the stronger your defense is. So now I'm going to turn the presentation over to Warren Rossman, who's going to talk about EEOC guidelines and recommendations for employees coming back to work.
John, thank you. I'm here to talk about really what happens when the employees come back in the door. And the first slide, that one, is an outline of really what an employer can do. The testing of employees, taking temperature, is that all right? Yes, it is. That's the short answer. Are doctors necessary? No, that's also the short answer. Asking about COVID-19 systems, short answer, that's perfectly okay. Requiring COVID-19 testing, that is very problematic. We'll get into that. Concerning taking temperatures, this does not have to be by a physician. If you have a nurse or somebody with EMT training, those would be the natural people to use for this. Although something tells me that the receptionist would also be a natural person to do this. The one objective test, of course, is taking the temperature. I mean, everything else is subjective. So that taking of the temperature, the good thing to do is to have a no-touch thermometer. And these cost $60 or $65 from Amazon. The person who's using that should know how to use the machine. I mean, you're talking about someone who, if they take a temperature and if it's over 100.4, that employee is going to be told to, go back home, and possibly for 14 days. So this person who's taking the temperatures has to know how to use the thermometer. That person should also be given the appropriate PPE so that they don't get sick. It should be a touchless thermometer. And going on to the next page, these results have to be kept confidential. In other words, people have to be trained not to go around saying, oh, John had a temperature of 106. That is suable. If records are kept of this, those records have to be kept separate from personnel records. And this applies for any employee medical record. They have to be kept separate. In fact, when EEOC personnel come to your office, that's usually the first thing they look for. Are your employee medical records being kept separate from your personnel records? And of course, if somebody does have a temperature over 106, this can't be told to other people. This should be kept confidential. All right, employees, and let me go back to temperature taking for one moment. The EEOC guidelines tend to suggest that the employer should be the one who's doing this. But interestingly, Ohio's latest general order, and I think it's 20-15, suggests that employees should be the ones taking the temperature. So, there's as long as someone's taking their temperature, and that was one of the first things I did when I got up today. I took my temperature, and that's part of our protocol here at Weston Hern. All right, what questions can be asked? Obviously, the regular COVID-19 questions. Do you have chills, fever, coughing, shortness of breath? Have you been near someone who has COVID-19? Have you recently been to a high-risk area? New York, New Orleans, Sioux City, South Dakota, where that packing plant is. Other inquiries, they have to be business related, or you're going to get into trouble with ADA issues. The question here has come up, should there be a checklist of these things that an employee has to check off every day when they come in? Might not be a bad practice whatsoever. Lastly, can you require medical exams? Well, what's the problem here? And this is a huge problem, is that there aren't enough medical exams. In other words, there are very few COVID-19 exams. I think we're only in Ohio, I know we're trying to increase it from like 7,000 a day to 20,000 a day. I don't think that goal has been reached yet. So the testing should only be done if the employee says, yeah, I've had the disease, or I think I've had the disease, or if I think someone in my house may have it. It's at that point that the employer can say, I want you to get a COVID-19 test before you return to work. Otherwise, it really doesn't make that much sense. I mean, if it's just an employee coming back to work, and if they are symptom-free and have a regular temperature, it really does not make sense and can lead to EEOC issues if you require a medical exam. Thank you. I think Jack is going to speak next.
Yes, thanks, Warren. Good morning. And I'll try to be brief so we have time for questions and answers. I think a couple things. John mentioned thinking out of the box, and I think you're going to have a lot of different fact patterns that you'll be confronted with that we won't address necessarily today. So you're going to have to do a lot of, I think, interactive process amongst yourselves. When you start to think out of the box, I would encourage you to confer with your legal counsel that you work with regularly to make sure that you're not crossing the line. And what I'll throw out there, because I thought there's no agreement on even on our office on this. For example, thinking out of the box for the employee that's at risk or fragile, and they want to take time off, I would just point out.
Jack, you're muted.
Am I muted now?
Now you're unmuted.
Okay, so I'm going to suggest, thank you. I'm going to suggest that talk to your legal counsel about such things as this emergency paid medical leave for 2 weeks off, where the employer gets a tax credit. So there are things out there, and I think you need to be thinking in terms of common sense. What is your primary goal? Your primary goal is to protect yourself, your coworkers, and your visitors or your customers from this virus that nobody really fully understands yet. So if you act reasonably and document, as John was suggesting, that is really going to take you a long way. So what can offices require people that are coming back into the office, whether they're visitors or employees? I'm recommending a standard set of, can we go back one slide? Here we go. Okay, a standard set of questions should be prepared and directed for everyone entering the office by someone assigned to handle that task. And as Warren pointed out, I believe it was Warren, make sure that person is trained. And I think a checklist is highly recommended so that it's a standard set of questions. There's no deviation from the standard important questions, and you're documenting it. As Warren said, the questions need to be relevant to protect the employees and the visitors from the direct threat of COVID-19. Next slide, please. So here are what I would recommend as standard questions. And this could be on a form where the employee actually, whether it's done on a paper form or electronically, They fill out the answers to this, and they initial it to document that they've answered it. Once again, it's got to be confidential. You can't be sitting out there where people can see it. Do you currently have symptoms? And you list the symptoms. And the symptoms list is expanding by the week. So, in addition to the fever, chills, cough, shortness of breath, we've been hearing about recent loss of the sense of taste or smell. And there'll be more symptoms perhaps as we get a better understanding of this virus. Have you or a member of your household been diagnosed with COVID? Have you had contact with a COVID positive person in the past 14 days? Here's the one that Warren was talking about. Have you taken your temperature today, and is it less than 100.4 degrees? Or you can administer it. I personally don't think it's realistic to expect someone to have, a particularly small office, somebody, an EMT or a nurse on staff that's going to take everybody's temperature as they walk in. It's certainly the gold standard. I don't think it's required. I do think it's required that you ask the employee if they have taken their temperature this morning, is it under 100.4 degrees? And that's called a certification that from the employee that they're healthy. But once again, the preferred method would be to have the employee take their temperature before they enter the facility. As Warren pointed out, there's not a lot of accurate testing available. And so it's not recommended that you actually administer testing. It's just not feasible. And I think it's a wise idea to have the employee sign off or initial this document, this checklist. Okay. As Warren pointed out, and I think John did as well, all this information is confidential, including the temperature. That's considered a medical record. And all you have to do is think in terms of everyone has a HIPAA right of privacy to their medical information. So you don't want that floating around and discussed amongst coworkers. Of course, if an employee or a visitor provides objective evidence in response to these questions that they are COVID positive or have been exposed to it, you got to send them home immediately. Here's where it gets a little dangerous. You got to be careful. You need to notify the people that were exposed to that person in the workplace or in the office that they have been exposed or may have been exposed to COVID-19, but do not identify the person that brought the exposure into the workplace. That's the confidentiality provision. Obviously, you got to thoroughly clean and disinfect the areas that that person came in contact with. Another caveat you need to be aware of, and this is stated in the governor's order, the health department order in Ohio, notify your local health department or health district of the identity of all individuals suspected of being exposed to this COVID-19, including the person that you understand brought it into the office. So that's the one point where you will disclose the identity. You are required to disclose the identity, but it's just to the health department or the health district. And why are they doing that? That's in theory, so there's going to be some contact tracing. Of course, you want to train your employees. You've got these policies out there that we're talking about, and these practices. It's not unlike sexual harassment. It's not enough to have a policy and a procedure if you don't make your employees and the coworkers and management aware of what the policy is and train them on how to implement them. So training and publication are important. Okay. So what are the precautions that need to be taken when the employee comes back into the workplace now that people are coming back in? Well, the employees must wear face masks at work unless they are sitting alone. And as recently as a week ago, the standard in Ohio was sitting alone in an enclosed workspace. And I've got that in quotes. That was the language used, meaning I would interpret that to mean you have an office, you can sit in your office and you can close your door. You don't have to wear a mask in your office, in your particular office. Well, that was modified last week. And now an employee who is sitting alone and distant from coworkers, 6 feet at least, if they're sitting in an assigned work area, that's the exact words used, they don't have to wear a mask. So I think that I would interpret it to mean, for example, somebody working in an open cubicle can be working without a mask on if there's a 6-foot distance from them and their coworkers. They're working alone. If people are coming into that cubicle area or walking closely by, they have to wear a mask. And we're finding out that if you wear a mask and you wear glasses, they steam up and it's a real problem. Okay, there are exceptions to the mask wearing requirement. And if somebody has a health reason, they have breathing restrictions, if it's unsafe to wear a mask. So you have to look at the standards here, other practical reasons why you can't wear a mask. If you have a disability that precludes you from wearing a mask, this all leads you into that interactive process, but a lot of it's common sense and makes total sense when you think about it. Let's go to the next slide. All right, now, what about people that are in the workplace, but they're the customers and visitors are coming in, all right? So the employees should wear face masks in the workplace, but it's not mandatory for visitors or customers. But interestingly, that was a compromise that I think our Governor DeWine gave based on political pressure. He left it to the individual business to determine whether they are going to require a mask or a face covering, can be a cloth face covering, for customers and visitors. So we're seeing that in the grocery stores and other similar places. I think that same standard applies for offices and workplace. So it's a business judgment by the business or the employer whether you're going to require visitors to wear face coverings. I think in that context, if you're going to require it, make sure you have something that you can offer the visitor or customer to wear. And it would be ideal, actually. I mean, this is in theory. I'm not sure we've still got face masks available, but have something available if you're going to require it. You have to enforce the safe distance, the 6-foot requirement. Let's go to the next slide. This is an interesting one. The order or standard, the safe in place standard, that was just issued on May 1st, effective May 1st, it says to minimize face-to-face contact between employees and customers and to substitute virtual and remote communications if possible. So that can be construed to basically discourage inviting visitors to the workplace. And that certainly comes to play in the law firm situation. Our offices are still locked to outsiders. Obviously, you need to post signage outlining the safety procedures, including frequent hand washing and the like. So make sure the signage is up, including physical distancing requirements. And of course, require and provide hand sanitizer, et cetera, for disinfecting. And you have to periodically clean the areas that come in contact with people. So when people are returning to work following an exposure, what do we do there? We want to require reliable and accurate medical tests to confirm that they are not COVID positive. So if they left because they were exposed, that's an appropriate situation to require a test, or at least to require a note or certification of fitness to return to work from a health professional of that employee. This note requirement is not in place if there was no evidence of exposure or positive, obviously. And once again, the test results are confidential. They're treated as a medical record. And as Warren said, it must be filed somewhere other than in the personnel file. Now here's, in the blue, it's kind of no balloons and banners with welcome back from COVID-19 celebration. I was thinking about the TV series The Office, and they're kind of typically doing stupid stuff like that. And that's, it's kind of a natural. If you know a coworker was out with COVID and they recovered and they're coming back, to welcome them back, but don't talk about COVID. I mean, once again, that's the employee's private information. If that employee wants to disclose it, then it's open to the public, but you don't want to be as the employer or the coworker broadcasting that coworker had COVID. Who knows what this long-term effect of COVID is? As I said before, the employer is obligated to notify the local health department of the person that was COVID positive. And I'm going to hand it back to John for his final statement. Thanks.
Thank you, Jack. The last question we were asked to comment on is, what is OSHA's role in this current pandemic, and what can employers expect to see from OSHA, and what are some recommended steps? OSHA has gotten some criticism for being a little bit quiet during this pandemic. But in preparing for this slideshow, they have come out with 2 or 3 position statements and guidelines and recommendations. So again, if you go on the OSHA's website, you can find the guidelines. And what OSHA says is, develop an infectious disease preparedness and response plan. Prepare and implement basic infection prevention measures. Develop procedures for prompt identification and isolation of sick employees. Communicate workplace flexibilities and protections. And implement workplace controls. Engineering controls like the plexiglass, implement administrative controls, work practices, PPE. And the OSHA position statements provide examples of engineering and administrative and workplace practices. But what struck me in developing this is that, you know, this first one, develop an infectious disease preparedness. And I don't think employers have these preparedness and response plans for COVID-19 or an infectious disease. So if OSHA comes and knocks on your door, the first thing they're going to ask for all this. So as an HR department, I'm recommending that you develop a response plan. Take all your measures and put it into a pamphlet and call it your pandemic response plan. Because if OSHA knocks on your door, they're going to want to see it, and so that you'll be able to hand them, here's my response plan. You may have an influenza response plan, but I don't think that's going to be enough. I think they're going to want to see what is your infectious disease response plan, because the flu and COVID are 2 different things. So I would just start, as you're developing your leave policies and implementing all these controls, at the same time, prepare an OSHA response plan. When OSHA knocks on your door, they're going to want to see what efforts you have taken. Have you explored all options to comply with your OSHA requirements? Now, some of you may have OSHA compliance programs that need annual audits or annual trainings. But because of the COVID-19, nobody's in the place and you can't conduct the audit or you can't conduct the training. So OSHA will ask you, well, did you conduct any virtual trainings? I thought that was a good example. Or what are your remote communication strategies? So again, as you're developing your telework policy, also take an extra 10, 15 minutes to label a document, OSHA remote communication strategies, and prepare a response plan. Have you implemented interim alternative protections? And again, that's the signage, the PPE, the staggered shifts, and they're gonna ask, have you rescheduled the annual activities as soon as possible? If you have done these 3 bullet points, explored all options, implemented interim alternatives, and rescheduled annual activities, OSHA will take that as a good faith effort to comply. The caveat is, if you haven't done these 3 things, OSHA will say, well, you haven't made a good faith effort. And then that will go into their consideration of whether to issue citations and the level of citations. So thank you for your time today. We hope this was helpful. We will circulate, we have given a copy of this to Holly Roberto and ACEC, and it has a list of some of our favorite websites. And we are available for questions if you have any. And lastly, here is the general office environment guidelines issued by the state of Ohio.
Well, thank you very much, John, Jonathan, Warren, and Jack. This information has been invaluable, and your experience in sharing this information as well as presenting this information has also been invaluable. So we do have a couple questions that I'd like to throw out, and please, Jack, Jonathan, or Warren, either one of you would like to address it, please do so. But we've got one question that's come up, is that we have some employees that are concerned about their coworkers and whether or not they, the coworkers, are taking the proper precautions when not in the office. For example, their exposure, things like that. How can we police people's, I guess, while they're at work is pretty much all we can do, but how can we make those employees feel more comfortable that in fact their coworkers are taking this as seriously as they are?
Jack, how would you respond to that?
Well, my reaction is I don't think you can police people away from the workplace. I think your best safeguard is to have strong policies controlling the requirements for people to enter the workplace, including coworkers, employees, and visitors or customers. So that brings us back to actually what Warren's talking about, requiring them to take their temperature at the front door and to give this certification that they have had not any exposures. Now, maybe that's a question to be added to the list of questions. Are you taking precautions so that you're not exposing yourself to these risks? But once again, you can't go prying too much into people's private lives, in my.
Warren?
Okay.
And we've had several discussions in the office about this because, for instance, I'm afraid of checklists because I feel that that after about the third day, people are just going to check things off willy-nilly. On the other hand, how do you deal with co-employee fears, which is, I think, going to be a very big problem? Well, one of the things, I think one of the biggest things is for the employer to do the temperature thing, him or herself. In other words, that's the one objective test here. And if the employer is doing it, then everybody knows, and if it's done every day, then everybody knows that everybody entering the workplace is at least they don't have a temperature. And that may be, the best way to deal with this, in my thoughts.
And Tim, I agree with Jack and Warren that we really can't be prying into what happens away from the workplace, but this presents an opportunity for the employer to, again, not brag, but broadcast. Even if John didn't wear his mask at Home Depot over the weekend, coming into the workplace, we are enforcing social distancing. We have signage, we have a cleaning regimen, we have plexiglass, you can brag about everything that you're doing, and all these controls and adjustments you've made to the workplace are meant to protect and keep people away from being exposed to people who may be carrying it. So you are providing a safe workplace, whether or not an employee doesn't follow the rules in their private life. If they come in, we're prepared for that.
Yeah. I think this, Jack, again, I think this goes back to the training that you need to have for your workforce. And so it may be remote training, a video presentation or whatever, but I think it's important to emphasize to everyone how serious this is. And I realize there's people out there that are saying things like it's only the flu, it's no big deal. I think they need to be educated, but you can't target people. I would suggest you want to target your workforce and maybe there's some good material out there from the state of Ohio, Dr. Amy Acton or whomever, that will convey how bad this can be if you're one of the unlucky people to come down with it. And we as the business or the employer want to have the safest environment possible. This is what our policy is. This is what our procedure is. We're not kidding around. We're going to enforce it adamantly and aggressively, and we're doing it for the work's interest, because we don't want you to get sick or your family to get sick, and we don't want.
Okay.
Any
Well,
other
thank you for those. Well, yes. As a matter of fact, it's kind of a little bit of an extension on that one, but we're running out of time, and I apologize that. But you had mentioned as far as the importance of taking temperatures. So it's really a twofold question. The first part of it is, what devices have you seen that work well regarding taking temperatures? Is it a mechanical device? Is it, obviously, I'm assuming it's not an old-fashioned thermometer and everything else. So that's the first part of the question. What tools are available that work well or seem to work well? And the other part of it is when do you take that? Because if an employee is testing positive, or let's just say has a fever, has some other problems, but you're taking that temperature at the front door of the suite or the building after they've already gained access to it and maybe even walked around a little bit, used the restroom, whatever. So when is the time to take that temperature?
If I could answer that. If you go to Amazon or Walmart and look under thermometers, and my wife and I had to do this because we didn't have a thermometer in mid-March and needed to get one. There are any number of touchless thermometers available for about $60 to $65. I think you have to be careful. We actually, we're not looking for a touchless thermometer, just a regular thermometer. And the first one we bought was too cheap and basically didn't work. The second one, which we got about a week ago, does work and is one of those new digital types. But these are available online, and you can get them within about a week or so. Again, Amazon and Walmart would be about the best places to go. And Walmart does have a website. Concerning taking temperatures, the ideal thing is to take them before the employee gets in the front door, but that may not make a lot of sense. I would be doing it in the foyer, in that first room, before they start walking around, before they go to the bathroom. The first thing that they do after they enter the door would be have their temperature taken.
Okay, well, thank you very much for that answer. And the last one is that you had mentioned a moment ago in regards to the family medical leave and emergency family medical leave. So with that being said, you had said that if the person is not ill, then they don't qualify, and that makes perfect sense. But in the event, especially under the emergency family medical leave, child care, I believe, is in one of those aspects or one of those indices or indicators that they are qualified. So could you speak to how the child care plays in to the leave right now and how to handle that?
Tim, your questioner is exactly right. One of the 6 reasons that allow an employee to be eligible for emergency family leave is if their school or place of daycare is closed due to COVID-19. Then they have to care for that child. If that's the reason, then the employee is entitled to 12 weeks of family leave under the FMLA. The first 2 weeks are unpaid, and then the remaining 10 weeks are paid at, $200 a day for 10 weeks. So that is one of the qualifying reasons, is childcare.
It's actually, there's a cap on how much can be paid, but it's basically about 2/3, 66% of your regular pay up to a cap of 200, or I believe it's 500, depending on certain things, which you're talking about. That's the Emergency Family Medical Leave Act. The interesting question that arises is, what if you are an employer of less than 50 employees, which means you're not covered by the federal statute? I think there may be some flexibility there, because the Emergency Family Medical Leave Act is defined in terms of smaller employees of under 500 or less, and maybe John has some thoughts. So the first 2 weeks are not paid. The last 10 weeks rather, would be paid at the percentage, 66% level, with a cap to limit the higher paid employees from getting more than a certain amount. And that's where that triggers it may trigger the first 2 weeks of that emergency sick leave that I was talking about earlier, the 80 hours of full pay. Once again, the important point to be aware of from the employer's perspective is there's a federal credit here. So it's not coming out of the employer's pocket in the long run, although it may be advanced by the employer with this paid leave, because normal FMLA leave is unpaid. So this is what the new legislation has done. And John, I don't know if you've got some thoughts on less than 50 employer.
Less than 50, I would presume that people are entitled to it. The only way you get out of emergency, if you're less than 50, is if it would jeopardize your ongoing operations. And if you're going to claim that exemption, you better be prepared to document why granting someone emergency FMLA is going to jeopardize your business viability. Otherwise, if you can't justify it, then I would presume that that person is entitled to EFMLA, even if you're under 50 employers.
Wonderful.
Because I would hate to be, have 30 employees, and my company, we're doing well, but I'm going to deny EFMLA, and then I get sued, and I have a 6-figure lawsuit on my hands, and the judge is going to say, show me where if you grant this working class Joe, a modest amount of leave, how that's going to bankrupt your company. And if you say, well, we might not go bankrupt, then you have a 6-figure problem on your hands. So I'd be very cautious when invoking that exception.
Definitely consult your lawyers before you make that decision. It's not unlike the proving that a disability discrimination claim where you refuse to accommodate, you get sued for failure to accommodate, and you want to say it was an undue burden on the employer. The courts bend over backwards to give the benefit of the doubt to the disabled employee. It's a difficult burden of proof to make. So it all comes back to kind of an empathy factor, a reasonableness factor that I think we should all be exercising.
Good. Well, thank you once again, Jack, Jonathan, Warren. It's been a wealth of information. You've done a wonderful job, I think, describing what the issues are and addressing them one by one. So I, for myself, have found it helpful, and I know the rest of us have as well. And so I'd like to thank you, and as well as Weston Hurd, and I also like to thank ACE Sioux Ohio and Beth for presenting this hour of information. So thank you all very much.
Thank you,
Thank
Tim.
you.
Thank you. Bye.